Good evening. This is Laws 12062 Alternative Dispute Resolution. John Milburn. It's week 10. We're dealing with special issues in alternative dispute resolution, in particular ethics and standards. But before we do that, I'd like to take probably most of the session tonight in talking about the first assessment piece, providing some feedback and giving some more particulars in terms of what it is that I like to see in a mediation session. Overall, I was very happy with the standard of the work. Thank you very much. Most of the mediation sessions were interesting. There were some really good dispute scenarios. People organised themselves well. People got their work in on time. There were a lot of positives to come of it. And I marked it pretty hard too. So thank you very much to everyone who contributed. And I enjoyed the process of marking. I'm going to take some time now to mention what I look for in an excellent mediation or conciliation. So in that sense, it'll be interchangeable. Please feel free to interrupt me at any stage, ask a question, or use the chat facility as normal, and I'll continue to monitor that. Okay, so feedback on the first assessment. If you were doing well, I'd be suggesting to you something like, initially you set the scene well, you were well prepared, and you presented professionally and appropriately. Most of you did very well in terms of the presentation, but remember it's a professional gig that you're doing, the mediation job, so dressing well and preparing well is always important. The opening is very important. So for the good ones, I was looking for people that were confident and clear from the outset. I would have suggested to you that you address the parties appropriately, and importantly, you built trust and rapport with the parties. That's even before you start. Now, when it comes to the start, the opening, if you did well, I'd be saying your opening was well prepared and it was well delivered. Your voice was clear and confident, and your manner was very positive and inviting. I would suggest that your tone was upbeat, and right from the outset you encouraged the parties to participate. You see, the fact is that, like the people who are involved in the session, within a few minutes of marking the assessment, I had formed a view as to whether you were likely to conduct the mediation session well or not. Now, if you think that's perhaps unfair, just think from your own experiences how long it takes you to make a preliminary assessment of a person or a situation. For me, and in reality the participants, it would be the same. And within the first few minutes, you start to ask yourself questions like, is this person who's before me as the mediator capable and confident and likely to do a good job? So those initial impressions are all very important. Now, if you had done well, I'd be saying that you then explained the process well during your opening, that you covered all of the key points, and it is very well done how you explained your role and your experience. If you did well, I'd be saying things like you explained that you're not there to make a decision or provide advice. And most people got that right. I'd be saying you explained the rules relating to without prejudice communications and of course the confidential nature of the mediation session. Where people didn't do so well is that in the opening they may have explained the confidential nature of the mediation session, but did so only in the context of one of three possible scenarios. The first is they may have said the process is confidential and my notes will be destroyed at the end of the session and I will be respecting the confidence. That's one thing. The second is that you need to explain that the process is confidential as between the parties. Most of you got that right. The third thing is to explain that the process is confidential within the context of private sessions. Many of you didn't get that, and I think it should be named, it should be stated in the opening that you give in the mediation, and then repeated at the commencement of and at the conclusion of each of the private sessions. They're the three aspects of communicate or of confidentiality I was looking for in the assessment piece. To get brownie points, to have something really special, you'd make a brief statement by way of explanation to the parties as to why confidentiality is important. And that might have been something about a statement of that you're there to assist the parties. The process is confidential so as to encourage the parties to make concessions, to extend offers, and do so safely in the knowledge that any concessions made or offers generated to the other party cannot be used in later subsequent litigation. It is essentially a selling point for the virtue of mediation. And if you explain that to the parties, if you give the confidence at that time, in my view, you're likely to get more cooperation from the parties, and that will hopefully help resolve the matter. So still on the topic of what I was looking for in the opening statement, I'd also be looking for a comment that you confirmed that you had no prior contact with the parties. And if you did, explain that. I was looking for a comment that you are impartial and you're there to assist the parties to come to a resolution of their dispute and not to make a decision and not to act as a judge or an advisor. So right from the outset, I'm looking for comments that make it clear to the parties what your role is in the process, what you expect from them in the process, and to ensure there's no misunderstandings. In a good opening, you would have explained the parties, you would have asked the parties to ensure that they had the appropriate authority to come to a final resolution of the matter, should you get that far. And genuinely, just even thanking the parties for attending is always a good thing to do. In the opening, you would have confirmed the voluntary nature of the proceedings. You would have gone on to explain, as I mentioned, that there may well be private sessions and talk about what happens in those private sessions. In the opening, you'd be establishing the appropriate mode of address. You'd be considering time constraints, and you'd probably explain your preference as to the order of speaking, so that when it came to asking for the opening statements, the parties pretty much knew what you had in mind already. You would certainly encourage the parties to listen without interruption, and during that time, you are maintaining good eye contact. And that's the hard part. You're referring to notes, but you might do so selectively without detracting from the connection you made with the participants. So they're all the sorts of things that I was looking for during the opening statement. Now, I've just noticed a few things on the chat facility. Lots of comments about different dialects and language manners. I like the Scottish and the English variations, I must say. Something a bit different during the sessions. All right, so if you have any questions, please feel free to simply unmute and ask. We haven't had much of that this term, so I encourage you to do so, or if you wish, use the chat facility. So what we've been discussing so far are the things that you would expect to have seen or read from me by way of feedback in terms of an excellent mediation. All right, so we're through the opening. We're now into delivering opening statements. If you'd done very well, I would have written something like, you were clearly attentive to the parties while they delivered their respective opening statements. And I do like to see and hear positive acknowledgement in relation to certain statements. It may well be that it's just positive body language, good eye contact, and appropriate nodding. It might be, or something of that nature. It might be questions, but you don't need much, and I don't like to see much interruption at all, if at all, when parties are delivering their opening statements. you would have said to the parties, look, I just want a brief opening statement. I want an overview at this stage. And the other party would have known that you would expect they would remain silent during that period of time. But nodding, maybe saying, is really important, because it says to the participant that you not only heard what they said, but you acknowledged what they said. You're not saying you agree with it, but it's an acknowledgement. Okay, I got it. I understand what you're saying. So that positive body language, a few little words, a few little sounds, is really important to engage the parties at that opening stage. If you'd done well, I would have suggested something like that you asked the parties to deliver their opening statements quickly, one after the other. You see, if you delay inviting the second party to provide a statement, then you do run the risk of alienating that party. Some of the mediations went for a very considerable time before I heard from the second party. And in those circumstances, you do run the risk that they may say, well, what's the point? I'm not even getting a say. It may not be as obvious as that, but they might think it. So moving fairly briskly through the opening statements, to my mind, is very important. And during that period of time, you are taking notes, but very selectively. Your eyes are going between the parties. You're working hard. You're being light on your feet. You're moving between the two, and you're ensuring that they're with you on this. That's all important. During that time, you're also acknowledging emotion and concerns and being ready to deal with interruptions, and many of you did that very well. Okay, so we're now through the opening statements. We're at the stage where we want to set the agenda. You would have explained as part of the process that the agenda is something which needs to be set, and it's done by you in conjunction with the parties. Perhaps in order to create the agenda, you would need to ask some questions. We'd ask open, clarifying questions. And if you did well, I'd be saying that you did ask clarifying questions well, and you did so appropriately. Part of asking those clarifying questions from the outset is for you to provide an appropriate summary of the positions, and I would be acknowledging that you did that and saying you did it well. Now, at that stage, still pretty early on, from a time perspective in the mediation, you're working with the parties to create the agenda items. You want the agenda probably be 3 to 5 points. A word or a few words is fine and preferred. So nice and simple. And my practice is to generate the agenda and then physically turn my piece of paper around, unless I'm using a whiteboard, and get the parties to look down at that piece of paper. Now, part of the reason is that it's the little bit of transition that I'm trying to make from them diverting their attention away from me. So in the initial stages, just for a while, during the opening statements, their attention is to me and vice versa. We create the agenda, and now we've got something that's literally and figuratively speaking on the table, and the parties are looking at that. They're coming to an agreement about the things that we need to discuss, and we're taking the attention away from me. Once we've set the agenda, we've worked with the parties, we stress this is your agenda, this is your dispute. And what you do is you keep the process moving. The length of time I've been speaking already is possibly, no, it won't say that. It would take longer than that to get the opening statements and create the agenda, but you're moving pretty briskly through this process. You're not getting bogged down on detail. And if you do find a party wants to talk the detail, we're politely but firmly moving them on. All right, so we've set the agenda. What I'm looking for at this stage is whether you have been providing equal attention and balance to the parties. So those of you who did well would have had a comment to that effect. Again, I'm looking for the way in which you question. The questions need to be open and clarifying as opposed to closed. Closed questions can be very dangerous in a mediation session. I'm sure you all remember what I mean by open and closed. If not, ask some questions on you, crew, and we'll get some discussions going about it. At this stage, we have diverted the party's attention from them to me, respectively. We've got their eyes going down onto the agenda. We've now lifted up again. We're in open session. And at this stage, literally, I'm starting to encourage the parties to talk to each other. And sometimes I'll say it and I'll use gestures and a combination of the two. I'm not saying necessarily immediately, but pretty soon we start to get the parties to talk to each other. Of course, the parties want to talk to you. You see, they see you as an authority figure. They see you as the person that they need to convince that their argument, their position is right. We're going to break that down. It's not a court. It's not, I'm not here for that purpose. I'm here to help them resolve their dispute. Part of resolving their dispute is encourage them to talk to each other. So if they start telling you things, if they start trying to convince you, just be upfront. Say, don't tell me, tell him, tell her. Let her know. And if they start to stray and they start to come back at you, even just a hand gesture, and they'll get the picture. And it's amazing how cooperative people are in that situation, because even though you're not taking control of the dispute or the factual issues, you are still very much in control of the process, and people respect that authority. So if you invite them to talk to each other, generally they won't have a problem in doing that. So if you'd done well, I would have seen that. I would have seen that you're encouraging the parties to talk to each other, and when required, you would have intervened, but you would have avoided the temptation to keep the focus of the discussions on yourself. So I was looking to see if you came in at the right time, if it was necessary. And then during that opening session, I was looking to see if you kept the parties in the first joint session for an appropriate period. Many of you went straight to private sessions. And I'm thinking, wow, why did we do that? So generally a rule of thumb is try and keep them in that first joint session for an appropriate period, also known as long as you can. That's in practice. I had a 4-hour mediation on Monday afternoon, and we stayed in joint session the whole time. Use positive body language. Keep the process moving along at a good pace. At that stage, I'm looking for evidence that you're thinking clearly and intelligently. I don't want you to dominate the process. I want you to allow the parties to contribute in a very meaningful way. I don't want you to take the dispute away from the parties. So it would be, if you did well, I'd be saying something like, you displayed an ability to ensure the parties understood what the other party was saying before moving on. It is important that part of your role is to ensure that there's some meaningful communication between the parties and there's a real connection between the parties. And sometimes that means just stopping and saying, explain to the other side how that made you feel. Did you understand that? If so, did you explain to the other party how you felt? Things of that nature. Now, all during this process, apart from the obvious, we're looking for good eye contact, we're looking for you to keep it moving. You also need to take care with power imbalances, and that may be a factor. It wasn't so much in what I saw in this assessment, but generally power imbalances is something you need to consider. Now, if you've done well, I'd be saying, yes, you're remaining focused on task. You're referring to the agenda appropriately, and you are encouraging points of agreement. Throughout the process, keep it upbeat. Okay, well, we're agreed on that point. That's excellent. We may have some issues of disagreement, but at least we're agreed on that point or these points. Let's get that down. I'll get that down in writing, and let's move on. So you remain upbeat and positive. If you've done well during that session, I'd be making comments like, you encourage the parties to work with you in the process, and you left the parties with no doubt that a settlement of the dispute is possible. I was looking for the parties to respond positively and reciprocate by showing a willingness to work with you in that process. I think early on, we had a little exercise where I invited you to just display different types of body language in scenarios. Just disinterested, sit back, as opposed to sitting forward, maintaining eye contact. So during that time, I'm looking to see if the parties are displaying positive body language in responding to what you're doing and showing, yes, a sign, I'm willing to work with you on this. I think you can get us there. All right, so all during this process, I'm still looking to see if you're using your toolbox well. Did you use silence at appropriate times? People don't like a vacuum. So sometimes if you're just not getting anything, people aren't just coming to the party, they're not responding, just use a little bit of silence. Maybe they'll fill the void and get you going again. Obviously, question of whether you're maintaining or managing interruptions, and all the time, whether you're listening and acknowledging. Sometimes, and I'll just go to gallery view now, sometimes we have a situation where people make emotive statements, and part of your role is to strip the emotion from that statement and relate the facts as a question back to the party who made the opening or to made that statement. So, that idiot next door is always playing his stupid music too loud at all hours of the expletive, day and night. So the noise levels and the time of day are both important issues for you. Is that correct? Strip the emotion, get it back to the facts, relay it to the party as a question. So if you did well, that's the sort of thing you would have done in at that stage. If you'd done well, you would have encouraged the parties to retain control of the content. So you're in charge, you're the boss, but you do it quietly and confidently, but they retain control of the content. You maintain control of the process. You're there to help them in their communication. You're not there to create the content. Your role is to develop appropriate means to convert the parties' positions into a discussion about the parties' joint interest. Remember we talked about that? The difference between the parties' position, principle, I'm not giving in, whereas their interest might be to resolve this matter so they can do other things. Okay, so that's the sort of thing that I was looking for during the first joint session. Now, private sessions. Some of you chose not to go into private session, and that's fine. You didn't have to for the assessment. I expected it, but I mean, you weren't marked down just because you didn't. But if you did, I would probably say you broke into private sessions at an appropriate time, and in doing so, you used appropriate language. You eased the parties into it. They went with you. Okay, I can understand. Yes, I'll go with you in those private sessions. That sounds like a good idea. And when you did commence the private sessions, I was looking to see that you did remind the parties that anything said during the course of the private session remains confidential. If you did well, during the private session, you would have counselled the parties, you would have provided some good reality checks, and you would have done it very well. During the private session, you would have debriefed appropriately, and you would have engaged in some appropriate counselling and reality testing. Now, during that period of time, it's an opportunity for you to encourage the parties to package some settlement offers and do so in an appropriate manner. It's not for you to act as a broker and receive the offer and then relay it to the other party. Technically, you can do that if you obtain that party's consent, but honestly, I never do it because you just become a broker, ferrying offers from. Get them talking. But before they start to talk, and while you're still in private session, say, let's see if we can package an offer. It may not be accepted, but let's see if we can package it appropriately. And then, of course, you have an opportunity to work towards comparing apples with apples, so to speak. During the private session, you would have encouraged the parties to deliver their own offers when you go back into a joint session. And during that private session, you would have continued to show active listening skills as opposed to being cut off or detached from the process. Now, in a conciliation context, you would have perhaps proffered your opinion and perhaps provided some expert advice. If so, you did that appropriately and you did it in a measured manner. In private session, you can embark on a degree of cross-examination, so to speak, but you wouldn't cross-examine in a joint session. But during that private session, if you did well, you would have encouraged the parties to think about the best alternative to a negotiated agreement, the BATNA, and the worst alternative to a negotiated agreement, the WATNA. I'm sure you remember what that's all about. Okay, so that's it for the private sessions. If you'd done well, I would have said you moved back into second joint meeting at an appropriate time and you created a positive atmosphere. The positive atmosphere is really important. It's a bit like the opening, it's a fresh start. You make an atmosphere which is conducive to a settlement. Congratulate the parties again. You've hung in there very well. You've made some really good progress. Let's keep at it. But you step back from the process. When I say step back from the process, I mean figuratively and almost literally. Where I was talking about the positive body language and moving in on the parties, when it comes to the second joint session, I do want the parties to talk to each other, and very often I will literally just move back a little. And what that's saying is, okay, it's up to you now. I'm just going to sit back for a little bit and let you discuss this and thrash this out. Obviously, you're still there, and having sat back for a moment, I'll often then just come back in. But it's just that little bit of sign to say, hey, this is your dispute. Encourage direct communication and, importantly, bring the parties back to a point when required to do so. Now, here's where the agenda can be very important, because right at the start, you said to the parties, or you encouraged the parties to tell you what the important matters are. Sometimes, if you have a bad mediation, during the second session, somebody will come in with a brand new issue, and that's bad. So that's why it's important to have the parties agree on the agenda before you get going too far. So if you've done well in that second private session, I would have complimented you on the way that you complimented the parties, the way that you identified points of agreement between the parties, and I would have said, yep, all of that's excellent and it's conducive to a settlement. During that second session, you are encouraging the parties to speak to each other as much as possible. Your voice is pleasant, it's professional, you remain focused on task, and you are trying to remain approachable and relaxed. So during all of that, the whole mediation session, if you've done well, I would have said, yep, you were unruffled, you were quietly confident, you were impartial during that period of time. The other thing is, some of you did this, but not many. During the joint sessions, it's not a bad idea, if you're really stuck, to encourage the parties to engage in brainstorming. Do that when it's appropriate. And if you have to, and there's nothing wrong with this, just ask for the parties for help. If you really feel all is lost, there's no way we can get this to settle, just be a bit upfront with the parties and be a bit honest and say, okay, I need your help. What have I missed? What can we do together to resolve this dispute? Can we resolve this matter today? Do it positively. Just smile. Make the parties feel this is not the end of the world. We can do this. This is fun. Let's come up with a settlement offer. The parties need to be encouraged. Maybe they need to be persuaded. Maybe they need to be cajoled, but somehow or another, you are going to lift them up by their figurative scruffs of the neck, and we're going to get this done. All right, so if you'd done well, I would have also said that you created an interesting factual scenario, and generally I would have said that your level of professionalism remained high throughout the process. You remained upbeat. You were, to quote Judge Kingham, light on your feet. You were confident, attentive, you displayed active listening skills, and you were creative. You remained approachable, but at the same time you were cool, calm and positive, and you made a connection. So, to quote again from Professor Ashman, by the end of the session, I was looking to see that you were probably exhausted and you had 2 new best friends as a result of that process. So that's all the stuff that I was looking for a really good mark in that exercise. Any questions for that?
Could I ask a quick question, John?
Yes.
What was a really good mark? Like, what was one of the highest?
I think the highest was 37. No one got 40. I think there was a 37 and probably a 36 or 2.
Thank you.
Okay. Now, things that didn't do so well. John said, the thing I found most difficult was not to drift into conciliation by making suggestions. It's really hard. Those of you that chose to do a mediation as opposed to a conciliation might have thought you were taking the easier one, but I think you're taking the harder one, because it's so hard to avoid making suggestions and taking control of the process. So thank you for that contribution, John. All right. Now, things that you might have detracted from an excellent mediation or conciliation. Well, firstly, if you appeared a little disinterested or you appeared to lack capability, you'd start to lose some marks. If you started looking down at your notes, that's not good. If you adopted a slow and unimaginative approach, or you displayed instances of uncertainty or stuttering, or you are uninspiring, then you're going to start to be marked down. You see, the mediation is not like a pure theory law. Here it's really get down and do the job that needs to be done. So the way in which you perform is important. So the people that like being in court and being advocates probably find being a mediator a little more comfortable, a bit more part of their usual work, because, well, they're show-offs, aren't they, really? So part of acting goes well with this. You'd be marked down if you took the dispute away from the parties. If you spoke too much, that's a negative. What are some of the other things that I would say you were marked down if you took away the dispute from the parties? Well, if you spoke too much, I'm sorry I'm doing all the speaking now, ironic, but okay, if you take away the dispute from the parties, you speak too much, you're displaying controlling behaviours, you're asking closed questions, you're subjecting the parties to cross-examination, you're asking the parties to focus their attention on you, the questions and answers all went through you, that's not good. You didn't encourage communication between the parties, and you acted more like a broker than a mediator. You know, like a real estate agent will somehow, I don't know why are there any, I'm sure there are agents who are doing this course. My apologies for those of you who do, but my experience with real estate agents is they always want to keep the parties completely distant, and they ferry the offers from one to the other. So many of you did that in the mediation session. That's not really good. So that's what I meant by being more a broker than a mediator, and, you know, extending offers from one party to the other. You were marked down if you showed signs of bias. That might have been because you alienated one of the parties. It could have been that you just didn't let them speak for too long, or you started to cross-examine one of the parties during a joint session, were giving the impression to the other party, oh, hey, he or she's on my side. There, look, he or she's hammering the other side. This is great. I mean, that's starting to show some bias. Or if you spent substantially more time with one party than the other in a private session. If you didn't retain control of the process, then you'd be marked down. So if the party started to talk to you, if they start to do that, just say, stop, tell each other how you feel about this. And you can use gestures just as effectively. All right, so the way I mark my marking technique, I'll confess there's not a lot of science in this, and to some degree I can be open to criticism that it's subjective, but this is what I do. I made the point that within the first 5 minutes, generally, I've got a fair idea how this mediation is going to go. That's how important the opening is. All right, and I'm not just saying that because it's me. That's what everyone will feel if you're in a mediation session. So after 5 or 6 minutes, I've given you a notional mark out of 10. I've multiplied it by 4. So it's a 20, a 24, a 28, 32, 36, 40. That's where I start from. And then it's like, you know, those worms that you see on those television debates. We haven't done that for ages. I'm showing my age now, so the younger of our participants won't know what I'm talking about. But they used to have these television debates between politicians, and they'd have this little worm that goes up. If somebody says something good, up goes the worm, and if they say something bad, down goes the worm. And that's how it was with me. So I'm constantly remarking, saying, that's good, click up, click up, click up, didn't like that, bring it down. And sometimes if something was really good or really bad, you'd go up by big chunks or go down by big chunks. So that's the way I marked it. All right. Now, are there any questions? Does anyone want to say anything? People are mentioning here they went to a mediation last week, went to a QCAT mediation. All right. Anybody wish to say anything? Just so that I'm not doing all the talking. No? Okay. All right. So that's yes, John.
About the QCAT mediation. I thought that all QCAT mediators were legally trained, but is that not the case?
No. QCAT has a wide range of people that are involved in the mediation session. Not all QCAT members are necessarily legally trained, but I don't think there aren't too many that aren't now. So you've got the president, deputy president, then the senior members, and then the members. Then you have adjudicators, and you have people that do mediation work. So there's a range of people that do mediation work in QCAT. Not all lawyers, no.
John, it's Jenny here.
Yes, Jenny.
I was the one that went to the QCAT meeting. I went to that meeting, the QCAT meeting, and personally, I felt it was very obvious that the lady had no legal background, and I felt that the other person, while she was in the private meeting with the other person, in some sense, convinced her legally that he had grounds to win. So when I returned and had a private session with her, it was a debate between negligence and contract. And he was operating under the contract rule. Well, I felt she was persuaded and felt she was trying to persuade me in the private session to, back off a little bit. Had I had legal advice, so on, to the point that I actually asked her, did she have any legal training? And I think it's necessary. That was something that became very obvious to me on the day, that I feel they should have some legal training. Because I think the legal training gives you some I don't know, different persona maybe.
I think you're on mute, John.
You got your mic muted.
Thank you. Thank you. Bear in mind, of course, that you may have thought you knew what was being said in the other private session, but you may not necessarily have known. And part of reality testing is highlighting the negatives. And I guess sometimes you can go too far and make it seem like the person has no chance. But it may have been, and I just don't know, Jenny, but it may have been that mediator was creating a similar impression, but in reverse with the other party. But I can't say. But thank you for your comment. I'd better not go more than that, though. Any other questions, comments? Anybody want to make any further statements about that assessment piece? All right. Okay, well, perhaps we could move on. The reading in the material, not much reading this week. Ethical standards and also some practice standards. The ADR has been developed primarily through professional groups such as lawyers and psychologists, but now there are ADR specialists. During the 90s, when I first started, there was no particular governing body. there are some there is now. There are some questions that come to my mind. Do we actually need a governing body? To what extent should the governing body regulate the newly created profession? To what extent do consumer laws, torts laws and contract laws generally apply to dispute resolution practitioners? Do we need separate code of conduct for ADR practitioners? Should different ethical standards apply to an ADR practitioner who acts in a determinative fashion, such as an arbitrator, to that of a mediator? What are the professional indemnity insurance consequences of developing a separate profession? Are we driving away lawyers, and will the ADR profession be populated by arguably less qualified communicators? And are we creating a multitude of different registration and ethical guidelines for mediators? National accredited mediator is not necessarily an FDR practitioner. So there's a whole lot of questions. I'm sorry I just raised questions without necessarily providing answers. But there is a fundamental question: is ADR a profession at all? And if so, are they covered by existing indemnity insurance policies? And I'm not sure there are necessarily answers to a lot of these questions. It's still a work in progress, because one of the advantages of coming into ADR now is it's still a new profession, and it's not as though you're competing against people that have necessarily been doing ADR work for 40 years. There's some now for 20, but it's still pretty new. All right, so if we are talking about ethical standards, then I guess there's a question about whether we need to document the ethical standards, and if so, why? Probably to provide quality benchmarks, or to satisfy consumer demand, to inspire public confidence, but maybe it's just to assist in the accreditation and registration process. So ethical standards are now becoming part of the regime, if you like. Have a look at the Law Council of Australia. There are some guidelines there in terms of process. So some of the things that you'll find in the mediator standards guidelines in the Law Council of Australia guidelines relate to what we've been talking about tonight. So, and these are mentioned in your text. So, for example, there are guidelines in relation to information about the process, impartiality, conflict of interest, competence, confidentiality, termination of the agreement, and recording the settlement. So if you want to go a little further and understand in more detail what is required of you as a mediator from a mediator standards perspective, have a look at the Law Council of Australia guidelines.
Can I ask a question, John, please?
Yes. Thanks, Sarah.
Just with regards of what is expected of you, I guess looking at one of the cases, I think Legal Services Commissioner Mullins, where that barrister was, well, he said that the court said that he should have disclosed the information that his client wouldn't let him disclose. He was working for his client as a legal advisor. He wasn't working as an alternative dispute practitioner. He wasn't the mediator. So why was he bound by the ethics of an ADR practitioner as opposed to the barrister guidelines?
I can't give an answer to that one, Sarah. Sorry. You're right. I mean, it doesn't make sense.
I think I read a bit.
Yeah, thanks, Audrey.
I read a bit on that today. They bound him by the Bar Association rules, the two for solicitors, barristers, and I can't remember. But I think he was bound by those rules, not ADR ethics.
Yeah, but if you went to the barrister guidelines, the very next one, I think that was 52 and 53, the very next one was something about he wasn't actually misleading unless he, in just not correcting. So if you merely didn't correct the opponent's statement, that wasn't considered misleading. So if you took the next one, it wasn't. And then one of the purposes of the barrister guidelines, the very early ones, is to act in the best interests of your client. And then another one was to not divulge information that's within that attorney-client privilege unless you have consent. So if you were going to take those guidelines, there was more to be considered.
I think it might have been 52. When you read 52, it has a barrister must take all necessary steps to correct any false statement unknowingly made by the barrister to the opponent as soon as possible after the barrister becomes aware that the statement was false. So I wonder whether that's the part where he was held to a higher standard.
I guess it's 54 then. It was straight after it. As a barrister will not have made a false statement to the opponent simply by failing to correct an error on any matter stated to the barrister by the opponent. So.
Well, I'm with you, Sarah. I was a bit befuddled by why that outcome was the way it was, when you don't have to, as far as I know, you don't have to help the other side get to the truth, as long as you don't mislead.
Well, the whole outcome was quite interesting in the end, because even though they did find him guilty, he was doing it to, he didn't get, he got a $20,000 fine and a public reprimand, but still it was saying that he was trying to get a good deal for his client. So even though he breached those rules, they weren't too harsh on him, which I thought was interesting.
Thank you very much. And in the solicitor's conduct rules, Rule 30 says a solicitor must not take unfair advantage of the obvious error of another solicitor or other person, if to do so would obtain for a client a benefit which is not sustainable in foundation in law or fact. So that might be another aspect of it as well. But I'm sorry I can't weigh in on any further comment on that. It might be useful, Sarah, to initiate some discussion in your crew as well. But thank you. I'd like to have a look at that in more detail. If you do add something in your crew, I'll certainly look at that as well. And Tony's saying, oh yeah, Catherine's weighed in the paramount duty to the court and promoting justice. All right, so thank you. All right, well, that's probably all I wanted to cover tonight. Thanks for listening to me. As you can probably tell, I'm pretty excited about the way mediations can be run and should be run. And I do hope that we have a number of mediators that become registered as such as a result of perhaps in part doing this course. All right, are there any questions before we wrap up? Okay, thank you very much. I'll stop the recording. All the best.